Thank you, Judge. The hearing is in the matter of CFI 070-2018 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Sharif Shifji QC. The defendants are not present.
Yes, thank you very much. Mr. Shivji, then, do you want to... I've read the skeleton argument. I've reminded myself of the terms of the order and one or two other matters. So you needn't take me through the background to the case, but it would be helpful, I think, if you could show me the relevant correspondence since the last order.
Yes, my lord. The
in section P, I think.
It is in section P. That's right. So the order that your lordship made on the 2nd of March was in fact served by the registry on Miss Alanud, who, as your lordship's order noted, was appearing for the 1st, 4th to 8th defendants. Yeah. And by way of background explanation, her address had been provided as an address for the service of those defendants pursuant to an order of the court. Would your lordship like to see that order as well?
Yes, please.
Yes, so that was an order of Judge Nasser, which appears at the beginning of the bundle in section B under tab 32A, which is page 126A.
Hold on. Yep.
And that was a reissued order, and that order gave permission for the defendant's legal representatives to be removed from the record, and also provided that the defendants should provide addresses for service pursuant to Rule 3717. And under that rule, a party where their legal representative is coming off the record needs to provide an address for service under Rule 9.15, and they can provide a physical address for service, or they can provide an email address. And the response that was received is at tab K, so bundle K, tab 513, page 6018.
Hang on. Yep.
And if your lordship turns to page 6019, there's an email at the bottom from the registry to Al-Tamimi. This is in relation to a series of emails about the appropriate address for service for the defendants, and that email explains the defendant's former representative had provided the court with the relevant contact details as per the below, and then there's the email address for Alanud and for Mr. Al-Hashimi. We weren't at that stage aware of the court's order of the 28th of January because it hadn't been served on us, so we wrote asking whether these were the addresses for service. We then discovered the existence of that order by looking at the DIFC court website, and if your lordship turns back to page 6018, there's an email from us to the registry, and I'd be grateful if you could read that, please.
Yep.
And then if your lordship scrolls up a bit, the registry's response is at the top of the page, and then the registry confirms that our understanding was correct.
Yeah. Okay.
So those email addresses are the defendant's email addresses for the purposes of Rule 9.15, and accordingly documents sent to those addresses are valid, constitute valid service. We know also that the emails to Miss Alanud, at least historically, were being received, because eventually Miss Alanud emailed the registry before the last hearing. I might just take your lordship to that as well, if I may, because I think that provides helpful background. That email is at K533, page 6347.
Give me a second. Six, 347.
Yes, my lord.
What number document is it?
That it should be tab 533. So K533, page 6347. And that should be an email from Alanud to the registry.
Yeah. Yeah.
And this was ahead of the last hearing. And this was the first substantive contact that Miss Alanud had made with the registry. And I'd be grateful if your lordship could read that as well.
Yeah.
Now, perhaps I could raise a couple of points on this. First of all, the reference to emails going to the junk email folder shows that the emails were getting there, and she eventually discovered them. We don't accept, I should say, that they were going to the email junk folder, and the shock that Miss Alanud expressed is something that we don't accept, because the defendants had known since back in December that we had issued the unless order application, and at that point they were represented. And although she says in the email that their earlier legal representative had concluded his services since December 2021, that isn't correct, because as we saw from Judge Nasser's order, those representatives were on the record until the end of January, and they even appeared at a hearing for the defendants in early January. So the idea that they had withdrawn in December is factually incorrect. But in any event, one can see from that email that, notwithstanding her explanation, the emails, she had located the emails even on her own case by that point. Your lordship will then remember that Miss Alanud appeared, albeit late, at the last hearing. It was Mr. Al-Hashimi for the third defendant who appeared first. He made his submissions, your lordship made an order, he then departed, and a few minutes later Miss Alanud arrived, and your lordship will also remember at the last hearing that Mr. Al-Hashimi expressed some surprise at the start of the hearing that Miss Alanud wasn't there, and he had said that he was expecting her to be there. Now at the last hearing, Miss Alanud, if we go to the transcript of the last hearing, which is page 7154.
Yeah.
Your lordship will recall that Miss Alanud applied for a stay of the proceedings on the basis of an alleged criminal case, but was unable to give your lordship the particulars of that case. Yes. And she said at the bottom of 7154, in a submission to your lordship, if you would just give me one more week and the lawyers that has been appointed from my family would email the DIFC courts with the information. That's the information about the criminal case. If you can accept that then, and then you'll...
You've gone mute.
I'm sorry, my file hit the mute button. Your lordship then explained to Miss Alanud that an application for a stay... This is page 7155.
Hold on. Yeah.
So your lordship explained that the application needs to be based on proper material, and then you asked for my submissions, but in fact Miss Alanud jumped in again and she said, Your Honour, I really do respect that, but please, if you can just give me 1 more week extension of time at least, we will email the DIFC court with the case number and the prosecution, as well as the criminal case that has been filed with the exact dates.
Yeah.
Now that was on the 2nd of March, and nothing has been sent. And that then brings me to what's happened since then. So at page 7448 of your bundle,
Sorry, hold on. Sorry, page what?
7448.
That's in the same section.
That's in section P, tab 569. It's right at, it's the last document in the bundle.
If you give me the tabs, that's the easiest way.
I'm grateful. 569, my lord.
Yep.
So this was the email from the registry to Miss Alanood serving your lordship's order the 2nd of March.
Yeah.
And we also wrote to Miss Alanood the following day. And your lordship can see that at tab 559 at page 7092.
Mm-hmm. Yeah.
And we sent the order as well. And in that particular email, we were asked about the costs because your lordship had made a cost order subject to the agreement of costs or detailed assessment, and we were looking to agree the costs, and we received no response to that. Then the next piece of correspondence is at page 7090 of the same tab.
Tab 7090.
That's right.
Yeah.
And this was a letter about the forensic expert. Your lordship may recall that one of the issues was the fact that well, the allegation that the Delma Group CEO had deleted all the data on his computer, but the computer was still available, and your lordship made an order that our forensic expert would have access to restore the drive. So we wrote about that provision and asked for access, and we received no response to that either.
Yeah.
And lordship can see the follow-up. There are just follow-up emails at letter 7087. There's 2 follow-up emails.
70 what?
87.
Yeah.
And we've not received any response at all. And the first communication we've had was the court registry's phone call just a moment ago to Miss Alanood. That's the first thing that we've heard since your lordship's hearing on the 2nd of March.
Yeah.
So we're in a position where there has been regrettably no compliance by the relevant defendants with any of the provisions within your lordship's order. And in those circumstances, we will be asking your lordship to enter judgment against the defendants. And your lordship will recall, and perhaps we can have a look at your lordship's order.
Yeah.
That there were sanctions for non-compliance, although your lordship rightly said that the question of non-compliance would be put before this court today. That order is at.
I've got it. Yeah.
I'm grateful, my lord. So the order, the operative parts of the order.
Can you remind me why the unless order application against the 3rd defendant was adjourned?
Well, Mr. Al-Hashimi appeared before your lordship. Right. He said he was in the process of trying to instruct his own legal representative. My understanding from what your lordship said was that your lordship wanted to give my client an opportunity to reflect on whether it was necessary to continue against the third defendant in circumstances where Mr. Al-Hashimi appeared to be saying that he had no assets and the third defendant had no assets. So I think my understanding from what your lordship did was to give Mr. Al-Hashimi time to instruct a legal representative and also time for my client to reflect on whether this was a defendant that was worth pursuing.
And I think also probably I was influenced by the fact that there appeared to be some engagement by the defendant.
Yes, that is correct. And we have, I'll deal with Mr. Al-Hashimi separately, but we have received some correspondence from him in response to our communications with him. Now, his application is not before your lordship today, and I will address you on him later.
Well, if there's nothing today about his position, then probably you ought to wait until he's present before you address about it.
Well, yes, subject to one point, which is that I wanted to draw your lordship's attention to the fact that we'd like to revive the application against him. And I appreciate he will need to make submissions on that, but I just wanted to draw that to your lordship's attention for timetabling reasons, because we'll need some directions on that in due course.
But I can't give directions on that without him being present.
Well, perhaps I can address your lordship on what we say the appropriate way forward is, and your lordship can then take a view. But anyway, that's not the main business of this hearing. The main business of this hearing is dealing with the other defendants who haven't complied with the order. Now we're looking at the order itself, and the
5, 6, and 8, isn't it, the main bits?
That's correct, yes, my lord. And there's been no compliance with any part of those orders. Yeah. And the consequences are set out in paragraph 11.
Yes, I think you and I may differ about our interpretation of paragraph 11. We had a discussion about this at the last hearing, but it seemed to me the point I was trying to get across, and I'm not saying I did it very well, was that the question of compliance would include a consideration of whether any failure to comply was insufficiently grave as to justify striking out. It doesn't arise, I don't think, now, because there's been no compliance at all. Yes. But therefore, your argument and your skeleton argument that the defences are now already struck out, I don't think is right. I think if you want them struck out, you need an order.
Well, that's. I mean, I'm in your lordship's hands on that. I mean, your lordship will have a view as to what your lordship meant in this order. But
well, strictly, it's not a matter of what I meant; it's what it says. But I think if you read the first sentence and the second sentence together, they don't. They do in fact allow some consideration of whether strikeout is appropriate, where the non-compliance is not so grave as to justify it. For example,
well, I appreciate that, but in my submission, my lord, we're not in that territory, and we would say, I mean, it may be academic, because in any event, your lordship has the power today to both strike out the defence and enter judgment, and that is always the relief that we've been seeking in this application since December. But in any event, my submission would be, I take your lordship's point that if there were arguments about compliance, then your lordship may well say this order doesn't operate, so that a technical failure would lead to a strikeout. And for today, I wouldn't disagree with that. But in these circumstances,
just for future, in case you happen ever to be addressing me on this similar thing in another case, I would next time seek to change it to may be struck out rather than shall be, and then that reads with the second sentence more happily. Anyway, we needn't fall out over this. But the only point of me mentioning it is I think you need something in the order, in your new order itself, striking out the defences.
Well, I'm grateful, my lord, and I apologise. We intended to try and capture the sense of what your lordship had said. Yeah. I'm sorry if we didn't say, but the point is noted.
Yes. Yeah.
So my lord, those points are understood. So the application, I mean, this all goes back to the application that we issued in December. We made it clear from the outset that for non-compliance, we were seeking a striking out of the defendant's defence and to enter judgment.
Yeah.
In our submission, these are serious failures. This court has now made 2 orders. The October order before Justice Giles and your lordship's order, and the defendants have fallen far short of what the court has required them to do, and there's been no engagement. Even today, we haven't had an explanation from Miss Allenood as to why she cannot be here. And in our submission, the defendant's conduct is, if nothing else, disrespectful to this court. So we would say this is the usual order where we find ourselves in this situation. And the documents that we have been seeking go to the heart of the defence. This is not some trivial oversight on the part of the defendants. These are the documents which would either substantiate or, we say, highly likely undermine their defence. And there could not be a fair trial of the action without these documents. I should also say that the way that the defendants have conducted this case has put the claimant to enormous expense and trouble. And we have complied, we say, with the letter of the rules. We've carried out a full disclosure exercise, effectively a standard disclosure exercise on emails and on our hard copy records. Those email searches were all agreed with the defendant's legal representatives. They then were subjected to an extensive manual review by qualified lawyers. We went through all that trouble and did everything they asked of us, and they have really done very little in return. So it is highly regrettable that we have been put to the trouble of essentially getting this case ready for trial, only for the defendants then not to do their side of things. And so in those circumstances, we say that the appropriate and just order would be an order striking out the defences and entering judgment. And that order, in many respects, is very similar in nature to the original default judgment order that this court made back in 2019. So to some extent, one is coming full circle, albeit some nearly 3 years later. Perhaps I could just take your lordship to that draft order, please.
I've got the draft order in front of me, yeah.
I'm grateful.
It refers to the court's order of 28th October 21. Is that Justice Giles?
That is Justice Giles, yes.
And the application I'm dealing with is your application of 23rd December, is that right?
That's correct, yes.
Right. If we can just go through the order, I'm persuaded, particularly in the absence of any response at all by the defendants to the order, that the strikeout is appropriate. It seems to me that we should delete this penultimate upon. That's the one having thereby been struck out. Maitha, are you able to follow this so you can draw up the order as a result?
Certainly, Judge.
I don't know whether you have the draft order in front of you, but we will delete, just above it is hereby ordered that. We'll delete the upon the defence of the 1st, 4th, 5th, 6th, 7th and 8th defendants having been struck out. And we'll insert a new paragraph 1 saying that the defence of the 1st, 4th, 5th, 6th, 7th and 8th defendants is struck out. I can't remember, is it one defence document or is it several?
It is one defence document.
So it's singular is struck out. And then 2 would be, the present 1 would become 2. Is that right?
That's correct. And I'm sorry, it's our mistake. There's a comma missing after the word 5th in that paragraph. So 1st, 4th, 5th, comma.
6th, yeah. And the 7th, 6th, 7th, and 8th, yeah. There's a comma missing, too much cutting and pasting in the next paragraph.
That's
so
right.
That's paragraph 3 again with a comma after 5th. You've given the date of 5th April. Is that the normal period?
Can we just check that? That's 14 days, or we'll just check that, please.
And next paragraph about interest, 9% is the official judgment debt rate, is it?
That's the rate in accordance with the practice option.
Yeah.
Perhaps I could just explain 4 for a moment.
Yeah.
Well,
4 or old 4.
The old 4, new 5.
Yeah.
The claims that I'm asking for a judgment on today are the straightforward debt claims under the facility agreement and the guarantees.
Bank facility agreement and guarantee, yeah.
That's right. Now there are other claims, and they may well be academic. Some of those claims for damages, etc. Also, during the course of the investigations we've done over the last few months, we think we might have further claims, including claims for misrepresentation and deceit and conspiracy. Now, those may all be academic, because it may be that the judgment that we get today we struggle to enforce. But I wanted to reserve the possibility of coming back to the court if that ever matters. And in particular, we may have to take a view on the limitation of some of those new claims. So at the moment, we're just asking for those claims to be adjourned with liberty to restore, and we will have to take a view in short order as to what we do about that.
Yes, I didn't see any objection to that. If the defendants want to say that you should have to make up your mind and proceed or not, then they can come to court and say so. Yeah.
Yes, agreed. And then 6 goes on to the costs of the action. Now I don't want to trouble your lordship at length on this. Your lordship has got a favour for the experience that we've had in the last 3.5 years in litigating this claim since the proceedings were issued in 2018. We have done things properly according to the rules, with the thoroughness and rigour that the court would expect, meeting the court's timetable. And this case is quite far advanced. I mean, we've completed effectively standard disclosure in the areas I've identified. The next milestone would be witness statements. I mean, as far as we were concerned, this case was heading for trial, and we've been preparing on that basis. The defendants have put us to an enormous amount of trouble. Your lordship will get the sense of it from the Justice Giles order, but that hearing was contested as to what document production we should get, and we've had to fight every way to get what they ought to have provided in standard production.
What order did Justice Giles make about expenses, about the costs?
My recollection was that I'll check, I think it was costs in the case, but I'll have to check, but I think we agreed that. And at that stage, our view was, without waiving privilege, that these skirmishes on disclosure are par for the course in heavyweight commercial litigation. I mean, we would say things have obviously changed since then, because it became increasingly one-sided. We did everything that the court expected us to do, and they didn't. So I wouldn't say that that's going to be a guide to your lordship as to what happened next, and your lordship knows what happened next. There was complete disengagement.
Well, just tell you what I'm thinking. It seems to me that the action proceeded up to a certain point, and I can't tell you exactly when, but maybe October-ish, maybe December-ish, on the basis of a fairly large commercial action, with the sort of skirmishing with good points, bad points, and everything else being taken, and up till sometime around then. And it's the non-engagement of the defendant since then which makes it a case, arguably, for indemnity costs. And if so, whether those costs should be on an indemnity basis, whether that should be applied retrospectively, or simply from the moment the things changed.
I hear your lordship on that. Perhaps I could take instruction. I'll continue my submissions on other points. I'll ask my junior to take some instructions on that point, and then maybe I can come back to that point shortly if your lordship's happy with that.
Yes.
If your lordship if you wouldn't mind, I'll just put you on mute for a moment, and I'll just pass a message to my junior, and then I'll be 20 seconds. Thank you.
Yeah.
I'm grateful, my lord. My junior will take some instructions on that. Just going back to your lordship's earlier question about the date for payment under, so that is in accordance with the standard rules. It's RDC 36.34, which gives a party 14 days to pay sums due under a money judgment.
Right, and it's normally set out in the judgment, is it?
Well, in my experience, it is. I tend to do this. So certainly, this is not the first time that I've done it.
Yeah, that's fine.
So if I may, I'll come back to your lordship's point about the timing for when indemnity costs might kick in, and we also, as your lordship ordered last time, ask for detailed assessment proceedings to start immediately if the cost can't be agreed.
Why have you separated out the costs since 2nd of March from the rest of the costs?
Because we've filed a cost schedule for those. Today's hearing, we filed a cost schedule, and so your lordship could simply summarily assess those costs if your lordship was minded to, and then we would avoid having to go to the expense of having detailed assessment on those proceedings. And we did that because we were concerned that we might face another adjournment application today, and in those circumstances, your lordship would want to know the cost of today thrown away if this hearing had to be moved.
Okay, let me have a look at your statement of costs. 568.
Yes, that's right.
What's the bottom line?
The bottom line is 213,000 dirham.
That's about a fifth of that in pounds.
That's about right. I think it might be a little bit more than that, but it's the exchange rate to dollars is 3.67. It's about I think $50,000-$60,000. Someone give me a figure. Okay. The sterling. It's £43,000 in sterling, my lord.
Yeah. What are the other expenses totaling 134,000 dirham?
So that's council's fees, and I would have thought the bulk of that is council's fees, because that's about half of.
I don't understand this actually. You've got expenses disbursements of 127, others of 7. Other what?
Let me just check.
Oh, I see. It makes those two figures add up to the 134.
That's right.
Right. So if 134 is council and other expenses,
Council and translations,
then what is the other half of the total? Another.
So this is the work done by the fee earners at Tamimi and working on the application, and we filed the 5th witness statement of Patrick Dillon Malone, and we've also filed a 6th witness statement. That was probably sent to you very shortly before this hearing, and I do want to address you on that in a moment. That's just on a discrete point. And I know your lordship won't have had a chance to have a look at, but that's something that's come in very recently, and I just need to explain to your lordship at some point what it is.
Right. Is now a good time? Or should we look at this bill? We'll just finish looking at this bill first.
Yes.
Why do you need 3 people attending at the hearing?
Well, I mean, this is a long-running matter, and as your lordship noted, until recently it was heavily contested. And one of the difficulties that we've had with the disengagement of the defendant is one has to be prepared for every eventuality. I mean, it does actually make our life much more difficult if they don't file a skeleton and they don't communicate, because there are a range of possibilities today, and we have prepared for them. We're expecting an adjournment application. There was also the possibility of a stay application. These are things that your lordship would expect us to be ready for if they came up. So we are.
5 hours each. And most of it's going to take 3 hours, this hearing.
Yes, well, I take that point, my lord. We may have to. Well, I agree. We'll only charge obviously the time that's been spent.
Yeah, but if you're seeking a summary assessment,
yes,
there's no good going away having got your order and saying, "Well, think about it."
No, I understand that your lordship's right on that point. That's a fair point, and I think there'll need to be a deduction for that.
So. Going up the way to attendance on others. Mr. Layden, 20 hours. Attending various people.
Yes, that's right. So Mr. Layden is the key associate. He's in fact qualified barrister, but he's the key person at Altamimi who spends most of the time on this matter. He runs this matter on a day-to-day basis.
Right. Okay. If you want a summary assessment of this bill, it's always a bit of licking one's finger and holding it out for the wind. But I could justify, I think, it seems to me there's 1 or 2 entries for time and so on, which are rather more than I would expect. If I were to say, I give you a choice, so I've been doing this recently, choice of summary assessment of 190 or taxed by the registrar, assessed by the registrar.
Well, I think I'll choose the 190. I'll have to decide on my feet, but I think I'll choose the 190 on the basis that it will save the expense of going through detailed assessment and the time costs money, and so I think it's better to have a figure. So I'm grateful for that, my lord.
So we'll put the I've lost the order now.
That was 737.
What I'm minded to do is to make that sum up, which is presently under 6, sum of 190,000.
Yes.
But that ought to come before the cost of the claim. So that would become, well, it would remain, in fact, it'll become 5.
I think that would become 6, I think, my lord, and then that would remain 6, and then 5 would be 7.
Yep. Yep. Right. We'll come back to those costs. You wanted to show me. Would you want to deal with those costs now, or do you want to deal with this latest affidavit?
I'm just waiting for instructions through my junior on where we are on that indemnity question.
Okay. Right. Would you want to show me?
I'm sorry, my lord. He is back. Can I pause your lordship for 20 seconds and I'll turn my back? I'm grateful.
Yeah.
So my lord, I'm grateful to my junior for just having liaised with my solicitors about on the cost point. So my lord, our position is that we're content for costs on the standard basis up to the date that the default judgment was set aside. But we say that was on the 20th of July 2020. Now, yeah. This just requires a little bit of explanation. Your lordship will recall that the defence that was then mounted by the defendants, which really has set the course for all the work that's been done over the last 18 months, was that they had no knowledge of the liability to the bank, they had no contact with the bank, and that their signatures on the bank documents were forgeries. That is the defence. That is the only defence to the action that they mounted in their defence. And all this money and time and effort that we've spent litigating has all been directed to that point. Now, our position has always been that that was a fictitious defence. And we've said to them all along, if that is your case, you need to provide your internal documents that will show what you know. Yeah. And they largely haven't, but the documents that we have managed to eke out of them have certainly undermined their position on their knowledge of the liability in the period around 2018. So we would say that their conduct in advancing a defence that essentially went to their honesty and accused others of fraud, which they've not been able to substantiate, was unreasonable conduct. And given that that has set the tone and the work for all of the litigation since the 20th of July 2020, we say that that's the point at which indemnity costs should kick in.
Right. I follow that argument. It seems to me to have some force in it. I always think it's easier to pick a round number, but I was going to suggest 1st August 2020 as being, so what I would order in terms of what is now going to be 7, I think, that the 1st, 4th, 5th, 6th, 7th and 8th defendants pay the claimants, it wouldn't be further costs, pay the claimants costs of an occasion by this action. Oh, sorry, I'm reading the wrong one. Pay the claimants costs of the claim on a standard basis up to and including 30th July. 30th July? Yes, 30th July 2020. And on an indemnity basis from 1st August 2020. Such costs to be assessed by the registrar if not agreed. Yeah.
That's fine. Can we say the 31st? I don't know off the top of my head what date the 31st of July was, but could we say up to the 31st of July for standard costs?
That's pausing. I couldn't remember whether July had 30 or 31 days. Up to 30.
Fine.
Up to and including 31st. Yeah. Standard basis up to and including 31st July 2020, and on an indemnity basis from 1st August 2020.
I'm grateful, my lord, for that. So if unless your lordship has any further points on the order, I don't, but then I perhaps could just take you to this point that I wanted to draw to your attention.
If you can liaise with my third, I'm sure you've got all that noted, but if you have any queries, if you liaise with Mr. Shivji, and I'm sure he'll make himself available, and any queries, just email me.
Thank you,
yes,
Judge.
of course. I am very much available. So I'm very grateful.
Right. Well, you wanted to show me another affidavit.
Well, I did. Can I just mention for this part of the hearing? This is some material that we have obtained from the onshore execution file. Now, our understanding is that there are no restrictions on the use of this material and no confidentiality concerns, but some of the material goes to medical information, and wearing my hat as a moment for an English lawyer, I'm cautious about referring to medical information involving another party in open court. So I was going to suggest to your lordship that this part of the hearing might take place in private, and the documents we've not put on the court file.
I don't have that application in context, though. I don't know what the application is about. What are you wanting to tell me about?
So
Okay.
what I want to tell you, well, if your lordship was content for this part of the hearing to be in private, then I can give your lordship a fuller explanation. And in my submission,
surely you can give me a very broad anodyne explanation in public, so that I can decide then whether to allow things to be said in private.
So yes, of course, and I wasn't. I mean, it's a slightly academic conversation because the defendants are not here. But this is not something that we would want to keep private from the defendants. This is only something I would want to keep private from the general public. So we've got no secrets on this point from them. And the documentation I'm about to show your lordship came from the execution file, which they're a party to, was filed by them in those proceedings, and they have also been sent a copy of this affidavit today when we sent it to the court. But I'll explain a bit more what it is, and then your lordship can take a view.
Is it relevant to some application you're making?
No, it's not. But there's some medical information about one of the defendants, which suggests that individual is subject to some medical condition. And we considered that although it shouldn't stop your lordship making the orders today, and we didn't think that the information would stop the defendant complying with the previous order, we felt that as a matter of completeness to this court, we ought to draw it to your lordship's attention, because it's the sort of thing that, in our view, your lordship would think that we ought to have told you about, simply so your lordship had the information to hand. So it is just background information about one of the defendants that your lordship may wish to know in circumstances where they haven't turned up, and your lordship is proposing to make an order against them today.
Right. Can you tell me which defendant it is?
It's the 8th defendant, and if your lordship requires a bit more persuasion on that, or wants to understand the point, it's the 6th witness statement of Mr. Dylan Malone, and it's only 3 pages, and maybe your lordship can. I'm not going to read it out in open court because I don't want to read it. Yeah, I'll be grateful.
But I need to get it first, and I think that means I've got to reload the.
It won't be. It's not on case line, so it would have hopefully been sent to your lordship by email, but we haven't put it on case lines because, again, we just didn't want there to be an argument about putting it in the public domain.
Give me a second then. I don't have it. I don't have it on either of the emails addresses that the registry uses to contact me. Martha, are you there?
Yes, Judge. Is it the 5th witness statement of Patrick?
It's 6th, apparently.
6th.
It's not on CMS. It apparently was sent by email this morning.
I'll double check, Judge.
It was sent just before the start of the at 12:57 local time, so essentially 9 a.m. UK time. And the reason for that was the translations had only just been received, which is why it was started so late.
Unfortunately, Judge, I cannot see the email list sent to the registry. Do you mind, please, sir, if you can resend the email to the registry?
Yes, my Altamimi will send it now. I think it was sent. I've got a copy of it that was sent. It was sent to the registry at difccourts.ae website. I'm sorry. I'm being told that maybe the exhibits had caused a problem. So I think we sent an email with a large exhibit, so that may be why it didn't come through. I apologise.
If you can separate it out this time, send the affidavit separately, the witness statement.
Yes, Molly, we'll do that now.
I'll tell you what, I'm going to, it'll probably take 3 or 4 minutes. So I'll close my picture and my microphone for about 5 minutes.
I'm grateful, my lord.
Yes, Mr. Shivji. I've read the affidavit, but not any exhibits because I haven't received any exhibits. I need to.
My lord, are you content to hear this part in private? As I said,
I'm not quite sure what application you're going to be making.
Well, nothing, my lord. This is simply.
If you're simply drawing that to my attention, it has been drawn to my attention, and I'm grateful.
Right. Well, that's all. That is simply the point that it struck us that your lordship would expect us to mention something like this in circumstances where the defendants weren't here.
What I think you ought to do, though, is because it's only fair to the defendant to know that I've been shown this matter, albeit not on a court file. So I think you should, whether through the registry or directly, notify the 8th defendant, I think it is, that this has taken place, or notify Ms. Alamud. Perhaps it's better rather than a direct notification to the 8th defendant.
We will. We did send a copy of this witness statement when we sent it to the court. Obviously, that was only an hour ago. But when we send over the order, we will explain in the covering letter that this witness statement and exhibit was put before your lordship, but has not been put on case lines and not put on the court file.
Yes, thank you.
Sorry, Milo, just to explain, the only reason we did that was that our understanding is this material isn't confidential because of where it came from, but nonetheless, one ought to respect confidentiality where it exists, and we didn't want to destroy any confidentiality that existed by putting it in the public domain. That's the only point. No,
I follow that. That's, I think, the right approach. But it doesn't seem to me that it affects the orders that I'm making today. Very well. So, if there's are there any outstanding matters on the draft order?
No, my lord, nothing on the draft order.
Very well. Martha, are you happy? You understand the order we've made?
Yes, Judge. Thank you.
Thank you very much. Then that concludes today's hearing.
But my lord, so sorry. Can I just raise one final point, if I may, drop your lordship? And I don't ask your lordship to make an order. I just wanted to flag this that
it's the third defendant.
Exactly the third defendant. Your lordship at the last hearing adjourned the unless order application as against him.
Yeah.
We discussed at the beginning why that was. Mr. Al-Hashimi has since written to us and the court providing some information on his judicial receiver of the third defendant. It appears that there are assets. We will continue to correspond with him about whether he would simply consent to judgment being entered. But if he doesn't, we may wish to revive that unless order application as against him. I mean, as I said, would prefer to deal with this consensually with him. But if not, we may have to reawaken that. If we do, it would save expense if that matter could come back before your lordship, given your lordship's experience of this matter.
Well, whether it comes to me or not, I think is a matter really for the registry. I think they will have in mind the fact that I think the system is that a judge dealing with a matter tends to carry on dealing with it, unless there is reasons such as unavailability. And of course, I can't guarantee that I'm around all the time. But in principle, I see no reason why it shouldn't come back before me. But that's, as I say, a matter for the registry, not for me.
Well, we hear that, my lord. Thank you. And then finally, sorry, I've just been passed a note by my instructing solicitors. For Mr. Dylan Malone's 6th witness statement.
Yeah.
The exhibit has been sent by link. So if your insofar as your lordship needs to dip into that, it is there just for your lordship's information.
Provided the summary. The summary seems to me to provide sufficient information for me to be satisfied that it shouldn't affect the order I've made.
I'm grateful.
Thank you.
So those are my submissions, and I'm grateful for your lordship's time.
Thank you very much. That then concludes the hearing today. Thank you.
Thank you.